On a cold January morning, as frost clung to the marble steps of the Supreme Court, a sense of anticipation filled the air. People gathered outside, their breath visible in the chill, waiting for a decision that would ripple far beyond the courthouse walls. Inside, the 9 justices of the Supreme Court did something rare. They spoke with one voice. Their unity was striking, a powerful signal that the issue before them transcended politics and ideology. Their unanimous decision sent shockwaves from Washington, D.C. to Silicon Valley, instantly capturing the attention of lawmakers, tech giants, and ordinary citizens alike. It was a ruling that would redefine our relationship with technology and the digital world we now inhabit. This wasn't just a legal debate. It was about your phone, your emails, your private messages, the digital trail you leave every day, often without a second thought. Every text, every search, every location ping suddenly felt more significant. The court's ruling touches the very core of privacy in the 21st century, with global implications. Newsrooms around the world scrambled to interpret what this meant for their own countries, as the boundaries of privacy were redrawn in real time. Tech companies, governments, and privacy advocates worldwide watched as the US set a new standard. Some celebrated, others worried, but all recognized that the rules of the game had changed. The question: in a world where our lives are stored on servers, who holds the key, government or individual? This question, once abstract, now demanded a concrete answer. The answer was clear and decisive. The justices' words echoed through the courtroom and out into a world hungry for clarity. This is a story about power, the power of technology to connect and expose, the power of government to protect or intrude, and the power of the people to demand their rights in a rapidly changing world. The Supreme Court's decision draws a new line in the sand, forcing us to confront the realities of our digital existence. The boundaries between public and private, once clear, are now being redefined. The conversation is no longer theoretical. It's here, now, and it affects us all. From living rooms to boardrooms, people everywhere are asking, what does this mean for me? We need to understand what happened and what comes next. The implications reach into every corner of our lives, shaping how we communicate, work, and even think about privacy. The world was watching, and the stakes couldn't be higher. Every eye was fixed on the Supreme Court, waiting for a verdict that would set a precedent for generations. This ruling isn't just about American rights. It's a statement on digital freedom everywhere. It signals to the world that privacy in the digital age is a universal concern, not just a national one. For years, a quiet unease has grown, the sense that someone is always watching, that our every move is tracked and recorded. The digital age has brought incredible convenience, but also new anxieties. This case brought that fear into the open, demanding answers from the highest court. The arguments were fierce, the stakes enormous, and the outcome would shape the future. The future of privacy has arrived, and it's time to pay attention. What happens next will define not just our laws, but our lives in the digital era. To grasp this moment, we have to look back. After the Patriot Act and revelations about mass surveillance, a fierce debate erupted: security versus privacy. National security agencies argued for broad access to digital communications, while civil liberties groups warned of Fourth Amendment violations. High-profile data breaches and tech scandals made the public realize just how much of their lives were online and vulnerable. The SecureNet initiative in 2024, lowering the legal standard for accessing encrypted data, was the final straw. The Digital Trust Alliance, a coalition of tech companies and privacy advocates, sued, calling SecureNet unconstitutional. The case raced through the courts, setting the stage for a Supreme Court showdown. The nation was poised for a decision that would define digital rights for every American. The heart of the case: does the Fourth Amendment protect your digital life as strongly as your physical one? The Digital Trust Alliance argued that emails, photos, and messages deserve the same privacy as your home. The government countered that modern threats require modern tools, and SecureNet was a necessary adaptation. The legal battle centered on the outdated third-party doctrine: should using digital tools mean giving up privacy? Lower courts split, and the Supreme Court took up the case, signaling its national importance. During oral arguments, justices pressed both sides, grappling with the profound implications. The stage was set for a historic decision. On January 15, 2026, the Supreme Court ruled 9-0 for digital privacy, striking down SecureNet as unconstitutional. Chief Justice Roberts wrote, "The digital trail of an individual is a deeply personal diary. To grant the government routine access without a warrant is intolerable under the Fourth Amendment." The court declared that digital papers deserve the same protection as physical ones. The unanimity was striking. Justices from all ideologies agreed. Justice Gorsuch added, "The principle must follow the person, not the server." The new rule: the government must obtain a warrant to access private digital data. The decision cast doubt on other surveillance practices and set a clear constitutional standard. The balance was struck firmly on the side of individual privacy. The political fallout was immediate. The ruling forced the White House and Congress to rethink surveillance powers and intelligence strategies. A bipartisan group in Congress began drafting the Digital Privacy Act to codify the court's standard. States with strong privacy laws gained new leverage, and a federal baseline was set. Privacy became a central election issue, with candidates forced to take a stand. The era of justifying surveillance with national security alone was over. Politicians now had to explain how their proposals fit the new constitutional reality. The decision sent tech stocks soaring. Finally, companies had a clear legal shield against government data demands. American tech firms could now assure global customers their data was protected by the U.S. Constitution. But compliance costs rose, as companies had to verify every warrant and build new legal systems. The focus shifted to how much data companies collect and how they use it, sparking calls for new consumer privacy laws. The ruling spurred innovation in privacy tech. Encryption, decentralized storage, and privacy by design startups gained momentum. Privacy became a market advantage, not just a feature. The economic landscape for technology was transformed. Tech companies now had to balance user trust, legal compliance, and innovation. The message was clear: privacy is a fundamental requirement. The digital marketplace would never be the same. This decision isn't abstract, it changes your daily life. Your phone, messages, and photos are now protected by a constitutional fortress. Activists, journalists, and minorities gain new security to speak and organize freely. But law enforcement faces new hurdles. Investigations may take longer, and some evidence could be missed. As a society, we must weigh greater privacy against potential risks. The ruling encourages digital literacy and the use of privacy tools. The privacy conversation is now national, not just technical. The court gave us a right. It's up to us to defend and use it wisely. The digital age demands new vigilance from everyone. Legal scholars across the country are calling this the most significant Fourth Amendment ruling of the century, a decision that will shape the future of privacy law for decades to come. The ruling has sparked intense debate and analysis in academic circles, with many experts weighing in on its far-reaching implications. Dr. Evelyn Reed of Stanford University describes the court's move beyond the third-party doctrine as a true paradigm shift. She explains that for the first time, our constitutional rights are recognized as following us into the digital age, protecting our personal data wherever it travels. This, she says, marks a new era for privacy in America. The unanimous decision sends a powerful, non-partisan message. Privacy is not just a modern concern, but a core constitutional boundary that transcends political divides. Legal analysts note that such unity among the justices is rare, underscoring the importance of the issue. Law professor Jonathan Turley points out that the ruling recalibrates the delicate balance between citizen and state. Now, law enforcement agencies are required to use more targeted, precise methods when seeking digital evidence, ensuring that individual rights are not swept aside in the pursuit of justice. But not all experts are celebratory. Benjamin Witts of the Brookings Institution warns that the decision could place new burdens on intelligence agencies, making it harder to respond quickly to threats. He emphasizes the urgent need for innovation and adaptation to keep the country safe while respecting civil liberties. The next challenge, scholars agree, is for Congress and the technology sector to work together. They must find practical ways to respect individual privacy while still enabling lawful investigations, a task that will require careful negotiation and new legal frameworks. The ruling's durability lies in its remarkable unity. Future attempts to weaken or overturn it will likely face steep resistance, both in the courts and in the public arena, as the nation grows more aware of digital privacy rights. The legal landscape has shifted dramatically, and the world is watching closely to see how America adapts to this new reality. Other countries may look to this decision as a model for their own privacy laws. The conversation about privacy and security is just beginning. As technology evolves, so too will the debates, ensuring this issue remains at the forefront of legal and public discourse for years to come. The Supreme Court's unanimous 9-0 decision marks a historic turning point for digital rights in America. This moment is a milestone, but it's not the finish line. It's just the beginning of a much larger journey. This ruling sparks a nationwide conversation about the kind of society we want to build in the digital age, where technology shapes our daily lives and our freedoms. The court has handed us a shield to protect our rights, but the true responsibility now rests with each of us to use it wisely and thoughtfully. We must openly debate the trade-offs between security and privacy, listen carefully to law enforcement concerns, and find ways to innovate while staying true to our constitutional values. This conversation isn't just for legal experts or policymakers, it's for everyone: families, students, teachers, and neighbors in every community. We all need to become more informed about how our data is used, what our rights are, and what's truly at stake as technology evolves. It's time to demand real transparency from tech companies and hold our government accountable for protecting our digital freedoms. The future of our freedom and democracy depends on our active participation, not just as voters, but as informed citizens who care about digital rights. Take the time to read about your rights, start conversations with friends and family, and ask your representatives what they're doing to protect digital privacy. The Supreme Court has opened the door to a new era. Now it's up to us to step forward and shape what comes next. This is our democracy, our digital world, and our collective responsibility to protect it for future generations. Let's work together to ensure that liberty not only survives, but thrives in this new digital landscape. Stay informed, stay engaged, and above all, keep this vital conversation going, because our future depends on it.